national AI strategies, recognize the importance of preserving the rule of law. Um, the 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 gap really is is in enforcement. And when you have a responsible AI framework that isn't really enforceable, that leaves a lot to be desired.
Thank you so much, Dr. Fola. You have talked about the state of play in Africa very, very comprehensively. And now I'd like to turn to Aseso. Where exactly are we seeing, just building onto what Dr. Fola has already spoken about, where exactly are we seeing the most promising and practical applications of AI emerge in the legal sector, including courts, judiciaries, etc.? And what misconceptions persist about the role and effectiveness of these technologies, particularly given that many AI tools are designed primarily for non-African languages, legal systems, and contexts?
Thank you so much, Doreen. And I think Dr. Fola has really laid down the foundation on the issue of AI in the legal sector. And now, just maybe briefly to touch, I think mainly in terms of the legal sectors specifically, I'll first delve on the issue of legal practitioners, primarily being counsel, that is advocates and lawyers. We find that a lot of persons engaged in legal within the legal sector, you are using AI for purposes of legal research and document review. We're also finding that this is especially important where there are large portions of documents that need someone to quickly review. And this also ties into the issue of the contract cycle management in terms of looking at huge bundles of documents or of contracts so that we can then be able to, advocates can then be, and counsel can then be able to extract meaningful information using from contracts that are quite bulky. We've also seen a way in which now advocates are moving towards litigation support so that then they're able then to attempt to see how they can be able to predict how certain cases, certain litigation would go, especially looking at perhaps how a particular judicial officer or a judge is likely to make a decision and arrive at certain decisions by having a way of which they can maybe have a predictive analysis of the way in which a particular judge is likely to rule. Because once you're able to then put in an array of the decisions that this particular judicial officer has then been able to arrive at over a certain period of time, you are then able to maybe have a way in which you can predict. Quickly looking at issues to do with the access to justice, I think AI can be used and has been used as a way in which we can push for access to justice such that particular facets of the community are able to use AI as a stepping stone before they then engage counsel who are then able to then formulate and move forward. But some of the pitfalls, as Dr. Fola has mentioned, is the issue of hallucinations and the fact that most of the AI tools that are in the market today are not generally fit for the African market, especially looking at the fact that within the African context, and now speaking for example, on the Kenyan scale, is that most of the AI tools that would generally be available to use are unable or are still not tweaked yet to be able to pick up on the local languages as well as Kiswahili as a language, such that then there becomes an issue where there may be an issue of lack of coherence between what the AI has developed and the actual input that has been given into the machine. And I think, for example, I know that the Kenyan judiciary is attempting to use AI as a way of transcribing court proceedings. And you know that, for example, within the Kenyan context, and when you look at the deep within the rural areas, you might find that there's inadequacy of language, of use of the English language, so that you find that particular litigants are then using their mother tongue, so to speak. And this finds a problem in terms of how AI perceives it. And this also goes as well to on the issue of the accents. And I think there's a wide array of accents first within the larger African community, and then when you go to the cosmic part of different accents within also the Kenyan sphere. And I think the issue of the AI learning the African accents is something that we should really be on the lookout for. And now I can quickly look at the issue of misconceptions. One prominent misconception is that AI is just a faster version of Google or a search engine, if you may, such that most practitioners are yet to fully appreciate how AI works, and that you really need to put in specific prompts so that you're able to get exactly what you want. If you just put in a search, let's say you are using ChatGPT, what is a thought? At least if you start using it in that manner, of course, you are not using AI as it should be, because that is something that you could as well have put into Google. A second misconception is that AI tools are neutral and objective. As I've mentioned, there's a big issue to do with from the development where they have been developed. Are they really neutral? No, definitely. They are subjective based, especially on where they have been developed from. As I've already mentioned, there's the particular aspect of not being able to pick up on the accents and the language used by within the African context. For example, in different African countries have their own unique languages in terms of where sometimes the prominent language, let's say, for example, English, is intertwined with a local language to give rise to maybe a third language. And I think it's, for example, we have the issue of the pidgin English within the Nigerian sphere, and what we commonly call Sheng within the Kenyan sphere. So AI is unable to really distinguish those issues. A third misconception I would say is that AI tools would work well within the African legal practice. I think this misconception is generally from the fact that we are told to look at some of these tools, so to speak, as ways in which we can then just, without trying to tweak the tools to fit our own indigenous spaces. And I think this just ties into the issue I've talked about language and all that. And I think maybe a favorite misconception of mine that I try to disabuse persons of is that AI will replace lawyers. This is far from the truth. AI is simply merely a tool that is then used by lawyers and others so that they are then able to work faster and maybe harness other areas that they may not be able to really be their foothold, but it is not a way in which can replace lawyers. And I think one of the best ways of looking at this is that As Dr. Fola has mentioned, there have been instances where there have been hallucinations from AI tools, and that we are getting phantom case law. For example, I think in our Kenyan jurisdiction, for example, there have been two widely shared instances, where one from the Kenyan Court of Appeal, where the Kenyan Court of Appeal in one of its judgments referred to the the Geographical Indicators Act that does not really exist in Kenya while we're writing a judgment. The good thing, or the saving grace in that, is that at that time, for that particular case, that Phantom Act was merely made reference to, did not form part of the basis of the holding of the case. And I think it would have been really very awkward for the Kenyan judiciary should that have been the case. And more recently, there has been a discussion, a decision by the court that is gaining quite a discussion among Kenyan advocates on the striking out of pleadings, where the judge ruled that AI was used to generate the pleadings. Therefore, the question then begs is, to what extent can is an advocate able to use the AI tools? I think that is it for me from now. I'm looking forward to continuing to listen to what we have in store for us. Thank you so much.
Thank you so much, Aseso. I think you've covered that very well. We've talked about the state of play in terms of the global and the continental commitments within Africa. And then we've also dealt with the practicality of AI within the legal sector and the common misconceptions that are there. So now we're going to move to the second segment, which is AI across the value chain. And now I'll ask Anne Salim, who is our innovation lead at Qhala, what AI applications are actually gaining traction in the African legal practice, and what does it genuinely take to build tools that work for the African legal systems? So we have African languages and African context, and these are different for different African countries, because we know it's not a one size fits all. Africa is not a country, it's a continent. So we have so many diversities. So there's a real difference between importing tools trained on data that isn't ours and building something that actually fits. What do you have to say about that, Anne?
Hello, and thank you so much, Doreen. Pleasure to meet you all. Good afternoon, ladies and gentlemen. I think the approach I would take to this discussion as a builder of digital products and innovation ecosystems is whether Africa will supply and consume AI built elsewhere, or we will consume and use AI built based on our local contexts. So across the world, we're seeing a ton of solutions, and as Aseso rightly mentioned, there's a lot of applications that in the AI legal space that are being used across the world. The ones we're importing from the West are especially the popular ones, and maybe I could reference some examples that I've come across, like Harvey, which one is another one? Do not copy. They have interesting names. They're really like legal research assistants or contract review tools, digital and drafting support tools. At Qhala, as ourselves, we've also built a deep research tool called Haki AI. But the biggest challenge we faced is if we don't build the tools to consume our data in our context, you will just have a tool that is not necessarily context specific. And that's usually the biggest challenge with any AI solution. So lawyers are already using AI, whether institutions are ready or not, lawyers are using AI. I think if you look across the world, even here in Kenya, probably the first legal tool someone will interact with is they'll Google their situation, right? On either an AI tool or not. And that, what do you call that solution? That chatbot that they interact with will give them a high level draft of their potential scenarios. So from building Haki AI, some of the things that I've realized are very important to consider as we are exporting or importing AI tools is Africa has very unique issues. From a legal perspective, we have case laws that are in various forms, and not all of them are digitally, the word is digitized. We have fragmented ways of interpreting different issues. When we look at how, how do I put the words correctly? When we look at how we make judgments and decisions and what we can access digitally versus what we have to access physically, across not just in Kenya, but if I go next door to Uganda or if I go to Tanzania, there's a lot of different legal precedences. So what I'm trying to say in a nutshell is African case law is fragmented. The legal data is poorly digitized. Not all of it is not digitized, but majority of it is still undergoing digital transformation. We have a lot of indigenous languages that are extremely underrepresented and many legal precedents are inaccessible. So then put that problem base in one bucket, and then now come to we're having these AI solutions that we're importing from the West, some we have built locally, that we need now to use to make meaningful use to prepare case judgments or digital documents. So that's the big challenge as a builder we are facing. Something we've navigated through when we were building Haki together with Law Africa and other partners is we learned that bringing different people to the table will help, because then they will contribute data sets that we can use for training the AIs. And when I say training the AIs here, I mean we upload a knowledge base to a repository, and then we tell the AI, I want you to look through these cases. And then anytime, for example, in the case where you're building a chatbot solution, anytime someone asks a question, return the information in this format. So those are the kind of things we're looking at as we're looking at the problem of building. So now to answer your question, there's a real difference between importing tools trained on data that isn't ours and building something that actually fits. So if I gave you any of those foreign AI tools, and of course, there's also the context of which type of law are we using? Sorry, I'm not a lawyer, no legal background, just a techie here. So I might mention some things out of context, but let me compare federal law versus what we have here in Kenya. I'm assuming it's British law or something, whatever is the law structure we use here in Kenya. The way of presenting the cases or the way of arguing or the way of litigation or mediation is slightly different. So a tool trained with those perspectives might struggle to be relevant in our African context. So in that sense, yes, legal technology is taking a lot of precedence. A lot of people are using the tech. But again, I'm arguing you cannot build meaningful legal AI using data sets from the West. You need to use African data sets. And then these AI systems must also understand our customary law, our religious law contexts, our common law systems, etc. So that's where we are at. Back to you, Doreen.
Thank you so much, Anne. You've given us the perspective from a techie point of view, which I think is important for lawyers to understand, because I think we tend to be locked in our legal bubbles. So now going back to the lawyers in the chat or the lawyers in the panel. So Dr. Martin, I'd like to now turn to you, and I'd like to ask you, how can AI transform legal and justice ecosystems across common law, civil law, and even hybrid legal systems, building onto what Anne has just said, and particularly in supporting legal research and drafting and enhancing compliance and regulatory practice? And I know you've seen this even as you teach the students at Daystar University School of Law, and how exactly can all of these AI tools improve judicial efficiency through better case management and reduction of court backlogs?
Wow. Thank you for having me here on this webinar, Doreen, and colleagues from the various parts of the continent. Just to say that we have a reality to deal with. The position that we should be taking, or I take as a lawyer who is both in practice and also teaching, is that we have tools in our reach that can improve how we draft, how we do legal research, and quicken how we can actually pull data together. One thing that you're saying, which is important, is that there is a platform around which AI is being built. For example, when you talk about, when I talk to lawyers about LLM and they're thinking about master of laws, The large language models are being done because they are embracing information and knowledge from across the globe. So what then is important is to build at least specific models around specific issues. So for example, we in Daystar are looking at how to actually bring all our information together, our cases within the Kenyan context into a platform where even some of our own dissertations, for example, are available, or information about these are available, and students can actually retrieve these. And what then it will do is that it will make them avoid trying to do topics that have already been dealt with. So that what we are saying here is that we have an opportunity to begin to take advantage of technology to make life easier for all of us. Obviously, we still have room for reading. We still have room for people to look at the hard textbook. And that is important because then some case law, some reports are still in the hard book. But there are now digital resources that are available, which can actually be made, put in spaces where students can reach them. So building something like a chatbot, local chatbot within the Daystar University is something that we're exploring, because what we then want to do is to ensure that in this space, students are able to actually get responses. You have a course outline you're looking for. Where is it? You don't remember whether it was in your email or wherever it is. To ask the chatbot, it will bring you that information, and you should be able then to use it for the purposes you want. Ask whether a topic has been discussed, and if it has been discussed, to what extent. It will tell you, this is what this one has said, these are the issues that were canvassed, these are the gaps that are here, and you ask, now what can I do? So the point here being that, how then do you interface with this technology? One, you need to have capacity. You need to know how to do prompt engineering, or you need to understand that prompt engineering is actually helpful for you to be able to then get information that you can get. So, for example, if you're looking for a context specific, ask, prompt it in such a way that it gives you the information that you want. So we will have to build capacity. We will have to interact with technology. Indeed, the judiciary in this country has already developed this AI policy. I know that in a discussion with the Law Society, again, we're exploring how we can build an AI capacity that will be able to be available to lawyers and have lawyers actually build up their skills. So the time is here. The judiciary has already embraced AI. Indeed, all the transcribing in the judiciary is now being done with the use of AI. The Zoom is using AI, Teams AI. So what we can get is a draft court proceedings that can actually come on real time. As soon as the court sessions are over, you can actually get the transcription done. So this is happening. It will help improve case management. It will help improve the speed around which things are being done. Earlier on, when Council Member Aseso was talking about replacing AI, replacing the lawyer, AI is artificial, and I keep arguing that it must also be met with human intelligence. Yes, artificial intelligence, but it has to be met with human intelligence. Now, human intelligence is strategic. A lawyer needs to know what they want, and therefore can tell AI to prompt AI to give them some of the aspects of what they want. But after the AI has surfaced for you, you now need to have the context and the content to be able to deal. So judges will have a slightly easier time. They don't have to spend time writing, AI is transcribing for them, but they can also quickly check the handwritten case management, and also the transcription from the AI, and that way things can be moved faster. So we have a situation here where schools of law have to come up, have to wake up. Legal practitioners have to realize that they have tools at their disposal. Obviously, a young lawyer or a lawyer who is equipped with AI proficiency is going to be a better lawyer than a lawyer who has no technology whatsoever. The time they'll take to draft for you a plaint, the time they'll take to draft for you an affidavit is going to be a matter of minutes, whereas drafting it by hand and drafting it in the traditional way will take you time. Indeed, now when employers are looking for employees, they want to know who is tech savvy, who is able to do things in the shortest time possible. So when you go there in the traditional way and say, that will take me 3, 4, 5 hours, somebody's telling you, no, that will take me 10 minutes, and this is what I'll do, and this is how I'll do it. So basically, we are here. We are saying technology is here with us. As lawyers, we need to embrace it, and we need to make it a part and parcel. And of course, as schools, we need now to enable our students. Gone are the days when we used to tell people, oh, why are you using AI? AI is available. What we now want to do is to build our own skills to be able to actually guide students and know what has been humanly developed and what has been machine developed, and see what has been integrated or what has been at least mediated between the human and artificial, and it can only improve the quality of that work. Back to you, Doreen.
Thank you, Martin. You've said a lot of things that have sparked my interest, and I know many schools all over the world are now, I think initially would say no use of AI. Sometimes even when applying for certain roles, you're told, don't use AI. If you're going to use AI, don't apply for this role. So now even in the legal sector and even in your teaching, and anyone in the panel can answer this from your experience across the legal field, how have you been able to mitigate the use of AI such that I think you've done a good job in building the case for the need for AI for a tool for efficiency and to do our work efficiently and faster. So it's cost effective, it's time effective, it's a good thing. But then how are you able to still have that intellectual integrity still at the core of everything, and being a good lawyer and not just being an artificial intelligence guru who can prompt engineer? Like, you still have those skills with you and you're not just heavily relying on that. Anyone on the panel can answer. Maybe Dr. Martin, you can start, and then anyone else can answer.
Yeah, I think we have arrived at a place where we are saying our students will use AI and are using AI. The question is, do you as a teacher have the ability to distinguish AI generated work that is not having a human interface? Are you able? And the question is not penalizing the student for using AI, but rather raising the bar to expect that a student who has had this advantage should be able to be operating at this level. And so my levels also have to go up so that I'm able to interact with the work. Two, the issue of ethical use is important. That I have a book to read, I can choose to copy the entire book and reproduce what the chapters are saying. That is like taking AI material, cutting it and pasting it and telling me it's your work. Or I can actually read, synthesize that work, and give it my own take and my own perspective on it. So AI gives you prompts, gives you some ideas, gives you some information. Then now you need to use that information to begin to give me an understanding that you know what you're talking about. AI has very flashy language. It says, you've asked me this. Okay. Now, I'm not a lawyer, but if I was a lawyer, this is what I was saying. Now, if you take AI that way and you just start giving me, running through the whole thing, then I'll tell you, okay, fine. But then where is your human voice here? What have you learned from this process? What have you synthesized here? Besides what you're just simply producing and putting together. So for me, we just have to up our skills. The place for reading is still here, and it must be there. But the place, because I can take a chapter of AI and even a contract, and I place it in a tool and tell the tool, can you summarize for me this? and it can summarize for me. But if I don't know what a contract, say an employment contract should be, or if I don't know what a construction contract should be, I will be misled, if at all I'm being misled by AI, or I'll be applying American law when I should be applying Kenyan law. If I don't know the Kenyan law, it will not work for me. So it's just a question of us being up with our game, up to date with our reading, and up to date with our law, understanding our statutes, and then being able to blend that with materials that we can get. And of course, the solution we are now dealing with is we also need to begin to bring issues within our context, and that way we have local examples, local case law, for which we can actually interact with better. So yeah, I am not bothered about whether or not students will use. The problem I have, maybe I should say this, Doreen, the problem I have is that if you have not read, we have been in a class for 12 weeks. I'm bringing an exam, and the only thing you can do is to come with your phone because I am giving you a question, you want AI to answer for you. That's where our problems begin, because first, we will not expect you to have a phone. And most universities are now beginning to discourage people from using computers. You have read, so we tell you, come. And here is a paper, start writing this thing. So we don't give you that advantage. But I can tell you, we still see phones that are being sneaked into classrooms. We still see earpieces and other things that are being used as aids so that students can have help with memory recall or whatever. But again, we're also beating that by asking them to apply. So the moment you give them a problem question, you ask them to identify the issues. Even AI will struggle to help them that way because they have to at least get it, apply case law, and give their own interpretation of it. Most times, that's where the trouble is. Back to you. Sorry.
Thank you so much. Even before I go to the other panelists, I can see Aseso's mic is unmuted, but I've just seen a comment that just goes in line with what Dr. Martin has said. It's from Constance Gikonyo, Dr. Constance Gikonyo. She taught me at the University of Nairobi. So she says that you have to make sure that the questions or assessments that you ask the students are actually application-based, which is exactly what you said. And you further then require that the application is at different levels. So that's something I think that lecturers across the board are now doing. They're going beyond, above and beyond what traditional teaching used to be. And now it's going to be more application-based, which makes it harder for the students to just be AI gurus. And you still want to make good lawyers. And I also like what Leslie has said. She says, forgive me if this is Leslie, he or she, sorry. So it says in the chat, it says, it's not the use of AI, it's the sophistication you use when deploying AI. We shouldn't look at AI used in an abstract way, but appreciate the skill used to generate the outputs. I really like that. And there's also a question here for Dr. Fola. Maybe we'll take it at the end. Or Dr. Fola, would you like to answer it now? It says, this is from Joe. He says, Dr. Fola spoke about emerging risks on AI being used by legal practitioners to cite fake cases. How do we manage the risks around these fake evidence being presented to our African courts, especially that we may not have experts to analyze the same? I'm sure Aseso and Fola can answer this.
Thank you, Doreen. I think let me just start by saying I like what Leslie has said, and I want to pick up from the point that they are saying that it's not just the abstract use of AI. We should look at it and appreciate the skill on how we use AI. It goes back to what I was talking about. We should be able to appreciate and get to know the prompts that we're able then to use, so that we are able to get the best out of our AI tools. And just then to hope on what Dr. Martin Oloo was saying. To me, on the issue of AI and what makes a good advocate, it's where I would say it's where modernity meets tradition. In terms of, we cannot leave out the traditional way in which, as lawyers, we are taught. That is, do your research, make sure you verify the information you have. That at least gets you away from, distinguishes you from being a robot, so to speak. That is just simply an AI lawyer, and one who's then using AI as a tool, so that you then go back to the basics. You do your research, make sure that AI is supplementing you, And just maybe to touch in terms of what the last part of the question, in terms of the evidence that we are getting and AI, we still have to make sure that our statutes, our laws, and all that are in concert with AI. For example, I've argued in a few places, for example, that, for example, the Kenyan Evidence Act needs a relook into how we are then able to introduce AI material within our judicial system in terms of AI, whether we can distinguish AI-generated evidence and primary evidence, so to speak. So then we just need to continue improving ourselves and improving the legal sphere. Back to you.
Thank you so much, Aseso. I'd like to open, if there's any, Dr. Fola, do you have anything to add on to that, the question that was specifically asked to you?
Right. So you can answer that question from both an individual and institutional level. As you've heard quite clearly, there's value in using AI within the legal profession, but there needs to be core commitments that as officers of the courts and legal practitioners we need to make to ourselves, right? That's why the use of AI for our work should be permissible and it's potentially useful for the work we do. These tools will only be of value and used by us with meaningful human review. So AI should support but never replace our analytical and nuanced contextual, legal thinking when it comes to the work we do. We need to be accountable to ourselves. Because the more AI becomes part of our lives in different respects, the more challenging it becomes to differentiate between, where the ways in which they are set up to operate intersect with our own thinking work. So that accountability to ourselves is needed, right? And we need to be selective and deliberate in how we use it with intentionality. So when incorporating AI into our day-to-day work, it may risk compromising the integrity of that work. That is why, as individuals and in consultation with others when uncertainty arises, we weigh the potential implications of using AI, especially within the legal context. Right? Certainly, while AI helps to speed up, our outputs, we need to make sure that we have this cognitive sustainability where as legal practitioners, we accept the necessity to find ways to protect time for deep reflections and legal work to use AIs in ways that support, sustained attention and thoughtful collaboration. That's at the individual level. At an institutional level, it's quite clear that judicial councils, law societies need to start publishing codes of conduct that will govern the use of AI. You don't prohibit the use of AI, because if you prohibit the use of AI, that is not going to be helpful to anyone. You need to publish guardrails around the permissible use of AI. And there are several examples from the African context and from global context where federal courts and judicial councils have published guidelines. And I think it's about time that in different African jurisdictions, we are looking at these practices elsewhere to develop our own codes of conduct. And we should be a living document to guide the use of AI within the legal and justice sectors.
Thank you so much, Dr. Fola. I don't think I could have said it any better. So now we're going to go to the next speaker and just highlighting what Susan said in the chat, which was what she highlighted what Anne had talked about, where she said you cannot build AI in Africa without using, by using data sets from the West or without using data sets that reflect our African nuances. And with that, I'd like to ask Yossra, when we think about access to justice in Africa, and access to justice is actually where AI holds its most transformative process or promise. And again, it's also has the greatest risk. If you think about access to justice the way it is now, even without using AI, it's very elusive in some instances. So AI does hold promise where it can be very transformative in ensuring that there's greater access to justice, but then there's also a great risk because it can further enhance marginalization of previously marginalized groups or already marginalized groups. So from your advocacy work, where are the communities most in need of that promise, and where are the gaps still most acute?
Thank you very much, Doreen. I'm really enjoying all of the interventions from all the previous panelists, especially Professor Martin, when you were talking about AI is here, but we need to really make sure that we use it in the right way, especially when it comes to students. Like they are calling us to use AI, but at the same time, to be AI aware of AI, but at the same not to use AI in the work we do, especially when it comes to the legal professions. And coming to the question, Doreen, I think the people who need legal support the most are those who are living in rural places. In rural communities who are underserved communities, and this is very common in Africa, which because they are the communities that they are far from courts, they are far from the legal institutions, they are also navigating systems that they do not operate in the language they speak every day. The languages they don't understand, so it would be even harder when we talk about AI tools using these languages as well, like French and English most oftenly. And when we talk also about these communities, we talk about their difficulties or their challenges when it comes to hiring lawyers or working with legal counsels. And I think these barriers or these challenges, they go beyond hiring, the cost of hiring a lawyer, because sometimes we even talk about the inaccessibility or the unavailability of lawyers in their communities as well, because lawyers are often based or centralized in 1 or 2, 3 cities, and they're not really accessible in these rural communities areas. So it's not only limited in the cost part, but it's also the unavailability geographically out of reach for these communities, but also it's inaccessible for them because of the language and the literacy challenges as well that they are facing. And most of the previous panelists also talked about how we can address these different gaps and how AI can help close these gaps, especially with increased AI literacy, with how to make a lawyer use AI to be a better lawyer, but not to rely on AI. And I think we've seen a lot of examples in Africa when AI has two double face of one coin, if I may say, when AI can really close these gaps. Even though for these communities, but also at the same time when AI can lead to a wrongful or misconceptions or even a misjudgment by courts or by jurisdictions. And unfortunately, today in Africa, we're still talking about AI tools. The existing AI tools that we have, they are all designated with urban, with more educated, and with more digitally connected users in mind. And they are not really designed or developed with the people or the communities that could benefit the most from these innovation, and which is, I think, a common challenge in Africa and in the different regions. And as I mentioned, it can have really double two faces, of one coin. We've seen examples, and I think some of them were mentioned also by Mr. Aseso or Professor Martin in Nigeria. We've seen AI tools helping communities and the people to access court decisions and to also understand legal advice in local languages, how they are also using local languages through AI tools in a country with over 500 languages, and the legal system is historically built on or only spoken English. So I've seen how Low Pavilion, which is one AI tool developed locally in Nigeria, it helped people and community to access digital court decisions. But at the same time, we've seen examples in Africa, like in South Africa, and I will bring back the example mentioned by Dr. Fola in South Africa, drafting their own national strategy, where I think lawyers might have been involved and included in the process of developing the strategy, which was pulled from the public because of fabricated citations, which they found out. So imagine if credentialed lawyers and experts who are involved in this process, they got it wrong, or they got this wrong. So imagine if an underrepresented or underserved person or community, they rely on these tools, but they don't have anyone to catch the error for them, and they will use these tools to maybe even make decisions on their lives or in jurisdictions. Even though this might go wrong, but I think also some examples there was like an experience, and I think it's also very famous. I've been following this also to social media in South Africa, the case of Mr. Makunga, who was a self-represented litigant against the company for damages raised from a breach of contract, and he used AI tools to prepare his own court submission. And at the end, the judge was informing, like, publicly that they were even better prepared than qualified legal counsel. So I think this is the promise that AI tools can make for people or for these communities, that they rely on AI tools. But there is also a need for double checking or fact checking, and also the human contribution, that it's not deniable in this process. And also Professor Martin mentioned a lot that AI is here, and we don't have too little AI. I mean, we have already a lot of AI that we're talking about, but we don't have enough people around it. We don't have enough legal experts. We don't have enough legal counsels and lawyers and legal clinics who are involved in AI work. Especially also, we don't have community workers or community members that they are working with lawyers and in the legal institutions as well, who simply can catch these mistakes before even they reach a judge, before even they reach a court when the decision can be made. Because if these decisions that carries, like, the languages, the villages' interests, they are not double checked, they are not verified, I think it will be more harmful than beneficial for all of them. And here I can finish with all of this. We've talked a lot about the legal, like the regulation and the legal professions, how they can be using AI, but all of this comes with a strong political will in our African countries. And I think, as Dr. Fola mentioned, we're having this political will showcased in having national strategies, even though it's becoming a race more than a strategic or an implementation roadmap for all of our African countries. So I think it starts really with developing these frameworks. It's true, they are important, but what's important is that to make sure that these frameworks, these strategies, or these regulations, they prioritize the democratization of AI and how AI is based on human approach and not the reverse. And I can mention here an example that we've worked, especially in the Francophone Africa, which is also an underrepresented region in the continent, where we don't see a lot of Francophone or French content around AI. And the first Francophone guidelines were developed for ethical, inclusive, and responsible AI, were developed with African countries, from local realities, from local experiences, with innovators, with representative from the ministries. And the guidelines, they set the standards for ethical AI and inclusive AI, when it calls that, and it calls also how it can be perceived by practitioners to support communities, and not the reverse, but also how to make sure that the democratization of AI is also part of our educational systems and curriculum in the legal like centers or the legal institutions across the continent. So I'll stop here because I think we will have a lot of other points to discuss later. But yeah, I'll hand over to you, Doreen.
Okay. Yeah, I love what you've said. You've said a lot, and I think it's very practical and it feeds into the discussions we've already had before. And what I'm really picking from what you've said is there's need to have more capacity building for people in the legal profession, be it lawyers and other judicial officers involved in the legal processes, so that they can enhance their knowledge on what AI and how to use it in the legal sector. I think that's very important. We can't just sit back and go about law the way we traditionally go about it. We need to integrate it within our systems, but then there's need to have a very ethical and nuanced way to go about it as lawyers so that we can actually meet the needs of the people that we are serving. I can see some comments in the group. So Leslie says, they like the example that Yossra has used about the South Africa, but I believe that these tools are only as good and effective as the posture the user brings to them, which leaves me asking myself, how effective are we at developing AI literacy on our own terms to help lean into our own trained models? Maybe, Anne, this is to you.
Yeah, thank you so much. We're actually having AI Literacy Week. It started from Saturday. And what AI literacy is, this is our second year running it as Qhala and partners across Africa, is we break down AI concepts into the most consumable version to different sectors. So, for example, this evening, we're meeting people in the education edtech sector, and we're going to be presenting some of our AI literacy tools for accessibility in that forum. Yesterday, there was discussions in the health sector, and we're talking about how we're building health solutions that are using AI health data sets from across Africa. Today, we're talking about law and how AI is impacting that. We've been doing this for many years, and Doreen leads some of our efforts across the continent. And so AI literacy specifically, we're looking at making sure that everybody can understand the terminologies, understand the technologies, and also know how to introduce them into their work or into their activities. But Doreen, over to you.
Great. Thank you so much, Anne. And Twahir says, to Yossra, you spoke about language and jurisdictional gaps. Many African legal systems operate in English, French, Portuguese, Arabic, and many local languages. Current LLMs, which are large language models for the lawyers in the house, still struggle with legal Swahili, Hausa, Amharic, etc. How do we avoid AI entrenching linguistic exclusion, which it tries to solve while it tries to solve access problems? Yossra.
Thank you. I think, yeah, it's very important because when we talk about African languages, it's not only in the legal sector, but I think it's different in the different sectors. Like when you talk about health, education, security, finance, I think it includes different sectors when it comes to AI deployment. And I think we need to also to move beyond simply deploying AI and focus on building inclusive AI ecosystems where African language are included from the design phase with local innovators and researchers and tech people or tech people like Anne mentioned. And this means the urge, actually, it's an urge for our maybe African governments or institutions, public institutions, to invest more in local languages data sets to put them available, because I know the struggle is not even to put them available for the innovators, but for themselves as well as owners of the data sets. It's also the urge to support research and development for African languages when it comes to Swahili, when it comes to Wolof, when it comes to other languages as well. It's to make sure that these languages are digitized and accessible from the beginning, from the design phase, to be included in the AI lifecycle and not be and not just trying to catch up with the development that is happening. And I think a most important step in this process is to involve actively the local communities and the legal practitioners, the linguist practitioners as well, and civil society organizations when it comes to the design and the testing of the AI systems with African languages. It doesn't, when we talk about today about AI legal, AI legal assistance that is designed and developed or trained on European law or a foreign law, it cannot be simply applied in Senegal or in Kenya or in Ethiopia or in Tunisia. It cannot. So I think there is a need and urge to contextualize AI systems when it comes to African languages that are grounded on national legal frameworks and not frameworks that are brought from the West or from abroad, that are also grounded on local traditions and culture. And in this way, I think this how we can evolve the jurisprudence of our countries as well at the same time.
Thank you so much, Yossra. I think you've said that well. And I'd like to steer the discussion back to governance, ethics, and professional responsibility. And Dr. Fola, I'd like to ask you, where should human oversight in the justice system remain non-negotiable? For instance, in sentencing, bail, custody, or risk assessment, and any other things that you could conceive within the legal sphere? And does Africa's current governance architecture give us actual tools to enforce those lines, or are we relying on norms that have no implementation, no enforcement, no teeth?
Thank you, Doreen. And I think it's quite clear from the conversation that has taken place so far that we all agree that we have frameworks that really lack no enforcement mechanisms. But I think what is also an underlying assumption in your question, relates to the issue of AI as a decision-making tool. And in these examples that is cited in relation to bail, custody, risk assessments, those fall outside of the judicial arm, and they are more or less administrative decisions that are taken by other sectoral institutions, either the police or a prosecutor's office and the like. So I would like to focus on this idea of automated decision making, because what we are seeing in Africa in terms of tech adoption, sometimes it's not necessarily full scale AI technology. They are potentially automated decision making systems. And when I refer to automated decision making, I mean decision making by systems which involve algorithmic processes, including machine learning in some cases, to automate human decision making. And there are two forms of automated decision making. The first, the first involves where situations where you have you know human intervention, and the second involves subsequent human intervention where the automated system serves as a tool to assist the human decision maker in exercising their judgment and discretion. In the situation where, in the first situation, which involves human intervention, a legal dilemma arises because there's no regulatory framework that can hold machines accountable for their decisions. So, public bodies who utilize automated decision-making systems remain responsible for their decision-making. And this accountability gap is heightened within the administrative justice framework, where government decisions within the justice or legal sector significantly impact the lives and the lives of citizens, like bail hearings, custody decisions, and the like. So there are three rights that are implicated when it comes to automated decision making: the right to administrative justice, the right to privacy, the right to access to information. And quite often, when automated making systems are presented, they are presented as an objective determination of facts, right? But this process does not take into account the fact that automated decision-making systems are engineered by humans, overseen by humans, and are used for purposes determined by humans. And the rationality of the decision-making that went into some of these choices in the engineering of the automated decision-making systems is also a subject that falls within the scope of administrative justice. So the role of public procurement then comes into play. because when any institution in the legal and justice sector decides to adopt an automated decision-making system to assist with administrative decisions, like, to improve efficiency, it's important that to have a robust public procurement assessment frameworks in place that helps you make the right decisions in tools that are context specific and addressed majority of the issues that Yossra has spoken about and Anne has also mentioned. So you have to link the question of human oversight in the justice system in relation to various administrative decisions to how you publicly procure these tech tools in the first place. Thank you.
Thank you so much, Dr. Fola. I think that was very comprehensive. I'd like to then now move to Aseso. Now, building on to what Dr. Fola has spoken about in terms of the things that we need to consider, we know that LSK sits or exists to protect the public from the profession itself, and it also protects the profession from the market. So it has a two-pronged role. In AI, those two functions are in tension because LSK sits or exists to protect the public from the profession and the profession from the market. So how should advocates be supervising AI-generated legal work? We've already kind of alluded to this in previous discussions, but I'm sure you can add or shed more light to this. And are the existing professional ethics frameworks on competence, confidentiality, and the candor in court sufficient to govern this, or do we need new rules?
Thank you so much, Doreen. First, on the first point, moving from the last issue that you raised. One, we do not have the current framework is not sufficient to in terms of making sure that we are protected within the AI sphere. What we have is that we have a variety of laws that are rather fragmented, but therefore, personally, I feel that there's need to have a consolidated body of law that then governs the use of AI, as it were, within both in terms of by the practitioners, that is the bar, and the bench. I think Dr. Oloo had mentioned this. I'm aware that the Kenya judiciary is currently developing its AI policy through CPIT, the Center for Intellectual Property and Information Technology, that is based in the Strathmore University. And the Law Society of Kenya as well, through the ICT and AI committee, which I convene, is also in the pipeline of developing its own AI policy to govern the use of AI within the legal profession. Of course, we'll need to get input from the users of this, the users of the policy, as it were, that is the advocates, in terms of what should go into that, and to what extent does a policy, like in this instance, fence in or fence out the use of AI. I think I had mentioned the fact that over the last 2 or so years, there's been an instance where 2 or 3 cases from the bench have emanated where AI has been used. Therefore, there's the question of to what extent can AI be used by judges and judicial officers to write judgments? To what extent is the human influence there? For example, the discussion that has long been going around is that once AI is used to generate a decision, and the decision, for whatever reason, is being challenged in terms of maybe inherent manifestation of hallucinations and such, is then the judicial officer the one culpable because of their use of AI, or are we then saying that the AI is the one that will quote unquote face consequences? And again, goes back to the issue of again advocates using AI. It's as has been mentioned by this panel, it's just supposed to be a tool, not the end of it. So at the end of the day, we still need to develop our laws through both the policy that the judiciary is developing, the LSK is developing, and as well as try to see what gaps exist within our laws that that govern the whole issue of use of technology within our respective spheres. So we still have a long way to go. What we can use now is still insufficient. We still need to brush it up. Thank you so much.
Thank you so much, Aseso, and I concur with your sentiments. And I'd like to move on to the advocacy arm. So, Yossra, we see biometric surveillance, electoral manipulation, and all of these things at play across the African continent, and especially targeting civil society through using AI tools. But these are not abstract risks if you think about it. So what does the legal profession specifically owe the public in responding to those threats? And from where you sit, are lawyers actually stepping up to these emerging risks with digital tools?
Thanks, Doreen. Yeah, as you mentioned, I think these threats of biometric surveillance and electoral manipulation, the use of the voters, the voters like votes or voices in the elections, targeting also civil society through AI is really real in Africa, especially in the conflict zones across the continent. We've seen and watched activists like being targeted by AI tools. Even some of them, even like they were shot in the Middle East. I don't know if you've heard about these like cases, but we are also facing this in North Africa, for example, like in Tunisia, where I come from. Activists, journalists also, and anyone, for example, advocating against the system or doing even research through AI against the system is really targeted by the authorities, and they can even be imprisoned without any legal foundation. So before AI itself, it was important to know the law for us, to know what's the plane as lawyers or as practitioners. But now with AI, it's a bit different. And the huge risk, I think, here is human dignity and privacy that are still very, very under discussed in our policies, in our frameworks, but also in our policy dialogues on the platforms that we have, in the summits that we have, in the different meetings that we have, because I think privacy or human dignity, they don't serve the big companies' agendas or the big tech companies as they are designing or deploying AI from a different perspective, and that it's not really that it cannot be a human-centered like approach. And where we think in Africa, as contextualized in the African context, it should be a standalone concern when we talk about privacy, when we talk about human dignity, when we about the African culture. It should be a standalone concern in every policy, in every framework, in every regulation, to insist on the risks and the threats and how we can mitigate them. And as most of the previous panelists also mentioned, that today we're still talking about AI readiness in Africa. And we're still in the phase of understanding what's AI, how it works, and how it can help us doing our work as legal professionals, as health professionals, as security professionals in any domain, in any sector. And I also think that lawyers today in the practice, they are still trying to understand how AI works and how it can give them, serve them in their work. And most importantly, how it can serve them to protect and preserve other people's rights and based on the law, and while also they're trying to preserve the rule of law, as I think Dr. Fola mentioned. And here we talk a lot about AI literacy that I mentioned at the beginning, that it expands also to lawyers and to legal counsels, which is very important, like for us in Africa, to prioritize training lawyers in surveillance law, in data protection, in algorithmic accountability, so that they can actually litigate these cases rather than just react to them after the fact. So I think this what should be the priority in most African countries, especially those which are most advanced when it comes to AI literacy. So answering your question directly, if the lawyers are stepping up, yes, they are. Some are stepping up as a professional. It's not yet at the scale or the speed the threats or the risk demands, I think. But what the public is owned is, it's not just the expertise of the lawyers, but it's also to have lawyers who are willing to take these cases when there is risk attached and no client who can pay. Yeah, over to you, Doreen.
Yeah, that's very profound. And I'd like then to move into what we'd see as the future of the legal profession in the age of AI or in this digital age. I'd like to go to Anne from an innovation perspective and just thinking about all the discussions we've had today to give you more insights on how to go about this, and even from your own experience. What structural conditions need to be present, be it from a regulatory standpoint, infrastructure investment? What conditions actually need to be in place for African legal tech to actually scale across borders and to have that cross-border effect of scaling up legal tech innovations?
Thank you very much, Doreen, and to the rest. I think my peers have said it very eloquently. What needs to go into place? I must start by highlighting that we don't have a legal tech issue. We have a bigger problem than that. We have infrastructure problem. So when I start with digital infrastructure for justice, I'm looking at the need for digitized court records, digital identity systems, secure document repositories, and open legal databases. So step one is we cannot build world-class AI on paper archives. That's the first problem. When I look at regulatory certainty, for us as startups, we need a lot of clarity when we're building these tools around AI liability, around data protection, and cross-border data flows. So in this situation, I'm looking at how can I sell to an investor that my solution, if implemented in country X or Y, will not come with a lot of legal liability. Investors usually hesitate to invest to fund the build of such technologies without that clarity. And then Africa has 54 countries. We're looking at regional harmonization. So from a compliance perspective, at the beginning, that's 54 compliances, 54 procurement processes, 54 regulatory interpretations. So at a regional scale, we're looking at things like how can the AU AI strategy, or how can we have smart regional standards or interoperable legal systems, so that when as we are building, we are plugging into a rail. And in this case, I mean, we're plugging into an infrastructure that already exists so that we don't have to replicate the process 54 times. So that's something to think about. And finally, looking at just investment, a lot of funding is going into consumer AI, fintech, and general enterprise tools, but not a lot of funding is going into building the actual legal data sets or the public interest AI. So in this situation, something that for me is really, really important is we don't need to build every AI solution, but we must create conditions that make it possible for innovation to scale. So in this situation, specifically with legal tech and AI, what underlying infrastructure can the governments across Africa put in place such that now when it's coming to us who are bringing in the technology, we can be able to customize it to work in local languages, to read legal data from African contexts, etc., and therefore make AI technologies specifically for supporting legal issues scalable for everyone. Thank you.
Thank you so much, Anne. And I'd like to now go back to Dr. Oloo, Dr. Martin, and Aseso. There's a question in the chat even as we wind up. Looking at, this is from Twahir. He says, looking at reality check on case management, court digitization in Kenya, Rwanda, Nigeria has been uneven. Where is AI actually being used in case management today versus where it's just a pilot or a PowerPoint? And what's the biggest bottleneck? Is it data, intermittent power supply, skills, or judicial buy-in?
Okay. I think the first issue is we need to build a framework. So a policy framework is critical. And I believe I've seen that's what the judiciary here in Kenya is trying to do. I must say that we are doing much, much better than one would have expected for a judiciary such as Kenya's, that for a long time was so manual and was so face-to-face based. To adopt virtual, to adopt electronic filing system, the court tracking system, to adopt transcription using AI. We are making progress. I think sometimes we beat ourselves too hard. We are making progress. To even go out there and say we have an AI policy, we are saying, look, we want to prepare ourselves to be where the world is going. So the judiciary is doing okay in Kenya. Does it have capacity? Absolutely not. Does it have resources, the infrastructure that it requires? The problem is we know it does not have. The problem is, do we know whether the executive will support them with a budget that they require in order for them to do that? And that becomes our source of challenge. And sometimes you want to think that you would want to see case management decisions come out faster. But you also want to think that those who are responsible for funding the judiciary are not necessarily excited about an efficient judiciary. They want it with backlogs and frustration, so that they don't become efficient. Remember, when the judiciary is efficient, one of the losers is the government, because it is forever getting court orders that are against it, and so on. So sometimes they don't even want to fund them because they think they are more of an opposition than anything else. So I think that we are making progress. I see that we have infrastructure challenges. We have capacity challenges. We have to build up most of those judges, most of those court research, judiciary research officers have to build up their skills, and we have to be with it when it comes to technology. But we also need to have localized approaches to building AI capacity. So basically, we are there. And I would say that it's better. Things are getting better now. You can get court proceedings faster than before. We can get debts. You can write to the judiciary through the system, through the CTS, and you can get a response. So we can only hope that we'll get better, but a lot of funding is needed, and not a lot of enablement, facilitation is required for the judiciary to turn around. And similarly, while the judiciary is improving, we also need the bar to be better equipped to respond to the judiciary as well. So we must carry these two things with equal weight, so that we are able to meet with the technological advancements that are happening globally, but within the bar and the bench. Thank you.
Thank you so much, Aseso.
Doreen, just quickly to just add on to what Dr. Oloo has said. Other than the bar, for example, we also need to carry along the other justice sector actors. That is, for example, the Office of the Director of Public Prosecution, or DPP, the Office of the Attorney General, the AG, and the Prison Department, for example. And for example, part of case management also involves an issue where we should be able to, the judiciary should be able to liaise with for example, the ODPP in terms of when charge sheets are brought to court, so that they are processed in a faster manner. So, but unfortunately, we find that where the judiciary is at is far ahead of where the other justice sector actors are, the ODPP, the AG, and the prisons, for example. I'm lucky to sit in the NCAJ subcommittee on ICT, where these justice sector actors also sit. And part of the conversations that we've been having along the way is being then able to also carry along these other justice sectors actors, so that they are almost at par, with the judiciary in terms of being able to the use of technology and the use of AI. For example, feel that the ODPP would perhaps greatly benefit from certain elements of AI in terms of being able to perhaps sieve through the charge sheets that are brought to court, so that to then be able to really hasten and make the issue of case management in terms of how charge sheets and all those things are processed a little bit faster. So it's something that we all need to carry along. But as Dr. Lo has mentioned, we are a little bit better in terms of where we have been, but there's still a lot of way for us to go. There's still a long journey that we must undertake, and we must undertake it together. Thank you.
On that note, Aseso, there's just one point on missing files. I'm not sure if you're in a position to deal with that question.
Let me try to get it before.
Let me read it out for you.
Yeah, I've seen from Tahir. Now, okay, and unfortunately, I'm not holding brief for the judiciary, but of course, that's an issue where the issue of the use of technology and AI can really assist. I think someone had mentioned, I'm forgetting who, that the issue of where we are in terms of technology is still a long way off in terms of transcribing, for example, even of proceedings, and where we are at in terms of evidence gathering. For example, the judiciary just started, if I'm not mistaken, the issue of the e-filing issue just because of COVID. And you remember that due to the way our judiciary and our legal system is, there are some cases that are as old as in the 1990s. So those documents, those files, for example, have to be scanned and then transcribed and such and such. So I think the conversations will still continue. I'll definitely pick it up, being within the NCAJ subcommittee. I'll definitely pick it up and see how we can assist in file imepotea manenos. Thank you so much.
Okay. For non-Swahili speakers, file imepotea is basically the file is missing. So Fola, now to you, so I'll ask you this question and then you can give your closing remarks, and then I'll go to the other panelists. So Fola, this is from Leslie. The question reads: before we develop our own sovereign AI tools, what laws and rules do you think we need to have in place first before institutions procure already existing ones that are in compliance with our own needs and values?
Thank you, Doreen, and thank you for that question. And apologies, I have to leave very shortly. So just to answer that question quickly, and in terms of next steps, last year the African Commission on Human and People's Rights, released a draft study on AI, human rights, and emerging technologies, and made some important recommendations about the application of technologies in different contexts. And some of those recommendations included conducting pre-deployment algorithmic impact assessments, having independent fairness audits, public explanation frameworks, and accessible avenues for challenging algorithmic decisions. I think these are some of the kind of frameworks that we need in place for us to be able to procure AI tools responsibly. We want algorithmic auditability, and it should be framed as some form of a mandatory contractual term to avoid vendor locking for certain technologies, and ensuring that public institutions who are adopting AI have the ability to access and audit the full algorithmic logic governing any system that generates outputs with potential direct effects on the rights of African citizens. So having very strong contractual clauses around data sovereignty and custodial data governance will be quite central to the management of these technological tools. Thank you so much for the opportunity to be part of this conversation.
Thank you so much, Dr. Fola. I take it now to Yossra. Please give your closing remarks. Then we'll follow with Anne, Dr. Martin, then Aseso.
Thanks, Doreen. I think I will end up with something Anne already started it when she talked about digital infrastructure that is needed, is to add on it that what we need more is the human infrastructure around these technologies and how it should be as strong as these technologies themselves. And this definitely amplifies to have more AI fluency, a mandatory and well-funded component of professional training across Africa, not only in the legal sector, but in different sector, not only about equipping judges or lawyers or the legal counsels with the skills to understand the use of AI responsibly, but also about ensuring how the policymakers and the regulators, those who are governing and putting the rules for AI in our countries, have a solid grasp of these technologies that they are tasked to govern. So it's really to emphasize and insist on how AI policies and regulations in our countries should be developed by institutions. Actually, they are developed by institutions with limited technical understanding of the systems they seek to oversee. And this is something that should be prioritized and should be overseen by the African governments as well. And it's important for us, especially at NIEL, through the work we do, capacity building for policymakers, for people working in the ministries, in the parliaments, parliamentarians, to try to shift the discourse and the narratives around the technology, to not fear this technology, but to think and reflect about a governance first approach founded on human rights and not the reverse. So yeah, I'll end up here. Thank you, Doreen. Over to you.
Thank you so much. Anne?
All right, thank you so much. I really enjoyed this discussion and learning from the fellow panelists. I mean, I'll start with a little bit of a controversy. I'll say lawyers who effectively use AI will replace lawyers who do not. So I think that's one key takeaway. But I think overall, when we look at AI, it comes with its risks. But the greatest risk is that if we deploy any systems, as a builder, at least for myself, if I deploy a system that's inaccurate, biased, opaque, and unaccountable in decisions that affect people's rights, then I'll be causing more harm into the society. So what can people do? I think we need to make African legal knowledge digitally accessible. And once we do that, it'll be the foundation for the future. And the algorithm will show that if the data we choose to preserve today by digitizing it, and we make it available to everybody else, then we're setting a good baseline towards where technology can now be used to deploy all these other effective, wonderful solutions. Thank you so much.
Thank you so much. Dr. Martin? If Dr. Martin, you're not able to hear me, Aseso, we can...
Sorry. What did you... Sorry, I missed something. What did you say?
No, we're giving our closing remarks. Then after you, it will be Aseso.
Well, it's been an interesting conversation, and I like the passion that I see here, particularly from the techie Anne here and yourself, and even Yossra. I think we are all in the same space, and what we are looking at is what can we do to ensure that we are not left behind? Gone are the days when development started in the north and we caught up with it 20, 30 years later. Now it is real time. They are ahead, we are ahead. We go, bumper to bumper. They can develop an AI tool, we can develop one. We can localize our hours, we can get local content. So let us get onto the African space. And I don't know who was talking about customary law and stuff. The point is, let us go and surface our real issues. Because some of these things we are being saddled with. I am now a big proponent of us going back to our roots. Mediation is not something that started yesterday. It's not alternative dispute resolution. It is the dispute resolution. So what we've done before, how we have resolved our issues, we need to bring that back into these spaces. We need to begin to infuse law with African experience, indigenous knowledge. AI is the place to go. So that when we're going in there, let us get things that speak to our traditions, speak things that have come out of African experience before we allowed ourselves to be overcome or overtaken by other people's traditions. Common law is the tradition of others. Issues to do with the president are issues of other, even as we have ours. So let's get back and mine it. So and Yossra, you take people, please give us things that will help us to find ourselves. It's not too late for Africa to find itself. Thank you, Doreen, and this has been an excellent. I think Qhala is doing a good job. I wish you the best as you navigate the Tech Week. You're doing a smart job. Thank you so much.
Thank you so much, Dr. Oloo. Aseso?
Thank you so much. I want to just infuse two things from Anne and from Dr. Oloo. Modernity meets tradition. I think that is the best way I would sum the issue of AI and the AI lawyer. AI will not replace lawyers, and as Salim has mentioned, an AI proficient lawyer will replace one who is not proficient in AI. And as Dr. Martin has mentioned, we then need to go back to our roots and just picking on that. The AI trained lawyer just remember to go back to what the traditions that root our legal practice in terms of being able to do the proper research and being able to read. We are called learned persons for a reason, and we need to be learned. We don't have to have technology learners. Thank you so much. And it has been a wonderful discussion. It has been a wonderful panel. Thank you so much, Qhala, for having me on this panel. Thank you.
Thank you so much, Aseso. Thank you so much, Yossra. Thank you so much, Dr. Oloo. Thank you, Anne, and thank you, Fola, who just dropped off. And we thank all the participants who joined the call and those who've stayed until this point. We really appreciate your giving us a listening ear and all the questions that you've asked us, including this last question from Juma, where they ask, how is the legal fraternity preparing to deal with synthetically generated data or deepfake evidence, should that be the case? I think Aseso had already alluded to the fact that there's the judiciary is working, Aseso and Dr. Martin had alluded to the fact that in the Kenyan context specifically, the judiciary is working on the judiciary AI policy, and LSK is also working on their policy. So with having that from the bench and the bar, we're able to see how both arms are trying to mitigate the adverse effects of the use of AI. So that would be the short answer on that. And I'd like to thank everyone who has been part of this, even those who have helped organize it, including Veronica, who has been able support during this call. And we thank you so much. And we'll have this session another time, another day, another place. Thank you.